were scandalized when I told you the story about the Empire State Building, and you should be. All judges know that, and they all said, sorry.
What's your opinion about moving the courts into the private sector? As some
You know, I'm aware of people who want to do that. I don't think that would happen in my lifetime, and probably not in the lifetime of anybody here. I'm hot and cold on the courts, having had a lifetime judgeship myself. You know, the judiciary is the anti-democratic branch of the government. Democracy is two wolves and a sheep voting on what to do for dinner. If the sheep doesn't have Second Amendment rights, or if there isn't a judge to enforce the sheep's natural rights, guess how the vote will turn out. The left believes that the majority always prevails. We believe that we have rights that even a minority of one can withstand the majority of everybody else. And sometimes only a court can vindicate a right like that. So the whole purpose of an independent judiciary is to be anti-democratic, to prevent the tyranny of the majority. Otherwise, there would be nothing to prevent, by a simple vote, the majority taking our freedom and taking our property. Now, I don't know if a private group could do that. It would require such extraordinary consent. It would take a revolution or generations of people with changed thinking. Sir, in the blue shirt.
Yeah, I'm very interested in that actual topic because from everything I'm hearing, it sounds like basically in order to get the things that are wrong fixed before a judge is just and determine things where we see things, you basically have to violate some law or have something happen to you.
You do. You do have to break the law or have some government come after you before you can challenge a statute. Now, that was included in the Constitution to prevent the court from having too much power, prevent the court from saying, well, we don't like this statute, we're going to declare it unconstitutional. The state courts, New Hampshire, has a procedure whereby you can get the opinion of the justices. You can take a piece of legislation and present it to the New Hampshire Supreme Court and say, tell us if it's constitutional or unconstitutional. You cannot do that in a federal court. Federal courts can only hear real cases and real controversies where some plaintiff has suffered real injury and is suing, or where the government has indicted somebody and the defendant challenges what the government wants to do.
So what that means is we have to stand up for our individual rights. So
yes.
For example, I'm a physician, so I've been hearing this stuff about how basically I'm going to be they're coerced in some form or another into accepting a flu shot that hasn't been well tested, in my opinion, driven by political fear and all kinds of other things. And I noticed even just last year, I got this email. Somebody was monitoring whether or not I had submitted information about being vaccinated because they don't know what I do if I see a physician. And in my opinion, the medical record, electronic or otherwise, is an extension of the promised privacy of the examiner. And it should be only a tool for communication.
You may have to risk your license, your professional career, and your fortune by breaking the law in order to challenge it. You can't set these things up. It's got to be a real violation of law. It can't be a collusionary lawsuit. It's got to be a real, legitimate lawsuit.
So myself and my peers need to know that and say
yes, they need to know that. Yes, they do.
We have time for one more questions.
In the back.
Yes. What do you think of the ideas of committees of safety for putting some teeth behind the 10th Amendment? And will you be having Edwin Vieira on your show?
Well, Ed Vieira was just on my show this week.
Was he? Oh,
he was. He's absolutely spectacular. Brilliant scholar who has the gift for explaining very complex issues in a way that non-scholars can understand. I didn't hear the first part of your question.
What do you think of the ideas of committees of safety as far as putting teeth behind the 10th Amendment?
Well, we talked about that earlier. The states need to nullify federal activity. If they just proclaim that they're sovereign again, that doesn't have any teeth to it at all. And the states should do it in a way that really challenges the federal government. I mean, many people in the federal government believe that marijuana should be lawful. They believe it because they think you should be able to put into your body whatever you want, and because it costs cost the government a bloody fortune to enforce these statutes. So that might be a very, very good test. If the state of Montana, for example, were to send state troopers to arrest FBI agents and federal prosecutors who interfered with the movement of marijuana within the state, that would create the clash.
You say one more.
What about people filing for affidavit of sovereignty, so that statutory law wouldn't, it would ensure that common law would override statutory law?
That is not something that, in my opinion, would work. I don't know who came up with that idea, but that defies 200 years of tradition. In a theoretical world, it would be nice if we only had the common law, which is the only crimes would be the common law crimes that you and I can understand, like crimes against nature, murder, rape, robbery, and these crimes where there are no victims, where nobody is really harmed by the crime, wouldn't exist. I don't see any chance of us getting to that point. I wish we could, but I don't see it happening. The government, remember, doesn't like freedom. The government likes control. So the government doesn't care if there's no harm or if there's no victim. When I was in law school, one could argue from the first day of law school on, what's the definition of crime? Crime is harm. Not anymore. Today, crime is whatever the government says it is, whether somebody's been harmed or not. Have a nice day, everybody. God bless.